My name is Ryan Chandrapala. I'm from Armchair Criminal. I welcome you all to this part of the program. This is the third part of a four-part series on Section 118 of the Criminal Justice Act 2003. At this juncture, we should be considering Rule 4 and 5, namely res gestae and confessions. However, as I outlined in Part 1 of this program, these topics are considered separately, as they should be treated as independent topics in their own right. In this part of the program, we will be considering the topic of admissions by agents. This is a very important part of this area because it affects various people in various capacities in very, very different ways. The defendants, those who attend police stations, those who attend courts, be it the magistrate court or the crown court, and those who do preparatory work as litigators. Before we go any further, let's remind ourselves what is said in Rule 6 of Section 118. So what is the statutory definition of admissions made by an agent? It says any rule of law under which in criminal proceedings an admission made by an agent of a defendant is admissible against the defendant as evidence of any matter stated, or B, a statement made by a person to whom a defendant refers. A person for admission is admissible against the defendant as evidence of any matter stated. You would have noticed that I have put the important parts of this provision in red square brackets. So, an admission made by an agent of a defendant. Two people are involved here, the defendant and his agent. Or, where the defendant refers a person for information to another person. That type of evidence is admissible in evidence. What is the difference between a confession and an admission? The difference is confessions are made by the person who's making the statement to his or her detriment. In other words, adverse comments. Whereas admissions are made on behalf of the principal by an authorized third party. To put it simply, confessions comes from the defendant or the suspect. Admissions comes from the person that the defendant has appointed. This is why I said at the outset, it impacts on various people. The defendant, the suspect, the solicitor at the police station, or the counsel, either in the magistrate's court or the crown court. So therefore one has to be extremely careful when we deal with this area. You can easily be called upon to give evidence as an advocate as to what was said in court. Now let's look at very briefly what is the definition of a confession. The definition of confessions and admissibility of confessions are governed by the Police and Criminal Evidence Act 1984, and you would find the definition of a confession in Section 82 of PES. And it reads, in this part of this Act, confession includes any statement wholly or partly adverse to the person who made it, whether made to a person in authority or not, whether made in words or otherwise. Therefore, you would note that there are certain concepts which are involved. The statement that is made must be adverse to the person who made it. In other words, to that person's detriment. The logic behind, would you make a detrimental statement that could affect you if it had not been true? Very unlikely. That is why. And to authority or not, whether made in words or otherwise. This is an important concept. Is there a definition of an admission? The short answer is no. An admission can be a statement favorable or adverse to the party making the statement. For example, yes, it is true that certain admissions could be favorable, certain admissions could be unfavorable. When you draft Section 10 formal agreements, agreed facts, they would include sometimes both. Next, I would ask is, who can make an admission? Admissions are made by the agent on behalf of the principal. It is Section 118, subsection 1, Rule 6. A. Identified who can make the admissions, agent of the defendant, and B. defines how the agent can be identified by a person to whom the defendant refers for information. Therefore, it begs the question, who is an agent? An agent is a person, any person, that the principal appoints to act on his or her behalf. This appointment is a formal procedure that one should take place. Should it be done expressly? In order to answer that, you need to look at the circumstances, because it need not be necessarily expressly, but it can be done by conduct. Yes, you would appoint solicitors by choice, because you are entitled to appoint your own legal team. But equally, there are instances where it can be inferred by conduct. In the case of Ravi, it involved drug dealing case, if I recall the facts correctly, and there was also several companies involved. In this case, it was held that the defendant's sister was acting as his agent, albeit that she was never appointed as an agent expressly. If you have an agent, to what extent an agent action will bind the principal? The extent to which the principal is bound, i.e. the defendant, to the extent the defendant has given authority. It is true that agents are regarded as having ostensible authority, and that ostensible authority can be used and be relied on other parties. The question to ask is, did the agent have the authority to do what he did? In short, the agents have ostensible authority to do what he did as far as the outside world is concerned, unless you show otherwise. Next question that I would ask, are there any characteristics whether the agent, i.e. the person acting on behalf of the defendant, has the authority? As I said, you got to look at the circumstance. It's a question of fact. It appears on the circumstances and the status of the person involved who can make the admission. I have the authorities here, and one of the cases that is interesting is a case by the name of Turner. And here it involved series of bank robberies. And a defendant by the name of Small had come to an agreement with the prosecution to become a Crown witness in return for an undertaking that he will not be prosecuted. And during the trial counsel has made admissions, and the Court of Appeal was asked to deal with the issues of whether the admissions that were made were binding. And in dealing with the issue, the Court of Appeal said there are two issues for consideration here. One, was the evidence admissible? Two, if so, should the judge have exercised his discretion to exclude the evidence? It's interesting to note that the Court of Appeal actually criticized the police getting into an agreement with the defendant, or could have been the defendant, Mr. Small, and said that basically it shouldn't have been. And the Court of Appeal said, one, the offers of immunity from prosecution should never be given by police and only sparingly by the DPP. Two, when a barrister appears robed before the court and tells the judge in a defendant's presence that he appears for the defendant, the court is entitled to assume that he has his client's authority to speak on his behalf, and that what he says is what his client wants him to say. 3. In the case of an accomplice evidence, the judge's discretion must make it plain that if the jury do not believe. Let me read that paragraph again. Paragraph 3. In the case of accomplice evidence, the judge's direction must make it plain that if the jury do not believe the evidence of the accomplice, his evidence must be rejected. However, his credibility is judged not on his evidence alone, but on all the evidence in the case. 4. Even for serious crimes, sentence should correlate sensibly and fairly with the sentence passed for murder, normal sentence of bank robbery, and goes on to explain that. So you would note the important part of it was that when a barrister comes to court fully robed, say, I represent Mr. or Miss Swanzo, the court will assume that the barrister has ostensible authority to deal with the case as he or she deems fit, to make statements that are made is because the defendant, he himself, wants them to be made. Otherwise, what will happen? The whole system will collapse. We will be stopping every 2 minutes to confirm whether the counsel had the authority or not. That would be unfortunate. But equally, it leaves the advocate in a very difficult predicament. That is why I tend to take endorsements left, right, and center. Some people virtually laugh at it. But you cannot be too careful on these things. It could easily happen the client will turn around and say, no, this is not how it happened, this is how it happened. And if there is no record of, then you could run into difficulty. In fact, there's an authority by the name of Downer, 1880, 14 Cox, CJA 486. One of the issues in that case had to address was whether to admit the evidence against the accused, a letter which his solicitor had written on his behalf. The solicitor said in evidence that he had an interview with his client. He was then asked by the prosecuting counsel, "Did you write this letter in consequence of that interview?" The solicitor replied, "Yes." The appellate court took the view that letter should not have been admitted, because just because the solicitor wrote that letter in consequence of interview doesn't mean that the defendant had given the authority for the solicitor to write. And it was debatable on balance whether it correlated with the solicitor's authority that was given. Consequently, the court said that letter should not have been admitted. What the court did say in the current case is one should consider, one, duly authorized agent can make an admission on behalf of his principal. Two, the party seeking to rely on that admission must prove that the agent was duly authorized. Three, whenever a fact has to be proved by evidence having probative value, is admissible to prove that fact. Therefore, in order to rely on section 118, if it is the prosecution who's seeking to rely, they would have to prove that the person was duly authorized. Of course, in the case of a barrister, fully robed, making submissions, that goes without saying. Even then, if the barrister were to go on a point without that authority, then the barrister is not covered by that point. This is why, my understanding, there's a rule at the bar that you must not call a witness if you don't have a proof. Because if you don't have a proof, how are you going to cross-examine? How are you going to lead the evidence? What evidence to be challenged? What not to be challenged? It's an important thing. But some litigators don't somehow feel that they understand the concept. Next authority that I would consider is a case by the name of Evans. Again, I have the authority. Here, the facts were that the evidence was adduced at the defendant's trial concerning the managing clerk's solicitor's firm approaching the defendant's brother-in-law, claiming that the defendant had asked him to ask X, another person that is, to say that the defendant bought stolen property from that person X. The defendant was convicted and he appealed. Here, it was said that the evidence should not have been admitted because the solicitor's clerk didn't have the authority to act as he did. There you would say that I mentioned earlier that it could have an impact on various people and depends on the status of the person. Next, we will consider how does the court view the documents prepared and served on behalf of the defendant to further the progress of the case. This is the part that I'm really concerned because this has a real effect on all the advocates. It's quite frightening. In the sense is, especially in the magistrates' courts, they tend to rely on PET forms or case management hearing forms to prove things as part of the case. And very often, things are done and said in a manner that could be questioned. Generally, the advocates complete various documents as part of the case management, are allowed to complete them without the risk of information being used as statements admissible against their client. Where the Crown seek to adduce those documents, an application to exclude the material could be made under Section 78 of PES. And not only that, the Crown technically should invoke Section 118 if they are to rely on the material. The case of Crown, Firth and Epping justices. Here it was a case where the defendant pleaded not guilty to an allegation of common assault, and a trial date was fixed. In complying with the criminal procedure rules, the defendant completed his part of the case management form through his counsel. The form was completed, and what it said was acting in self-defense. To be precise, let me refer to the case. The defense counsel who represented the female defendant said it's self-defense. Then later on, the prosecution raised the charge from a common assault to an ABH, and the matter proceeded to committal proceedings. In the committal proceedings, the prosecution wanted to rely on the admission made by the defendant, because the situation was there was an issue as to the identity. Here the defendant, having said that it is self-defense, what that person has done is actually put herself at the scene. So in order to overcome many difficulties of identification, they wanted to rely on the case management form. When the matter came to the appellate court, the issue was whether the Crown is entitled to rely on the admissions made by the advocate at court, on the basis that the admission was made by an agent, namely the counsel. And the issue was, if that can be done, does it infringe the rule against self-incrimination? Or is it a question that the court should always keep PET forms, PCAP, PTPH forms being adduced as evidence? I.e., should they be allowed in or not? What the court did say, referring to paragraph 17, this is what the court said. The common law principles in relation to admissions made by agents in the context of criminal proceedings were considered by the Court of Appeal in the case of Turner. Lord Justice Lawton set out 3 principles. First, an authorized agent can make an admission on behalf of his principal. 2. A party seeking to rely on an admission must prove that the agent was authorized. 3. The court is entitled to assume what the barristers say in court on behalf of his client is said with his client's authority. Lord Justice Lawton went on to say, if the court could not make this assumption, the administration of justice would come to a very difficult indeed. This is why I said earlier that when a barrister is in court, makes certain statements, the court is entitled to rely on them on the assumption that it has been approved by the counsel's client, the lay client. Therefore, what the court did say is, yes, pet forms can be admitted in committal proceedings as much as they can be admitted in trials. The court also, very correctly, if I may say, considered the possibility, would this have been an issue if the allegation had not been raised to a Section 47 committal proceedings? Because it was at that point, it was considered the issue of identification. Just out of interest, let me refer to paragraph 32 and 34. The court said Mr. Kraut put forward possible variations of his argument. At its broadest, he contended that no pretrial admissions made by a defendant's lawyer could, in any circumstances, be used at a subsequent trial. This would have the result that if a defendant in interview by the police admitted presence at the scene of assault but claimed to be the victim, that evidence would go before the jury. Whereas, if the defendant maintained a no-comment interview, but on the first hearing before the court, his counsel, with his full authority, told the court that he admitted to being present but claimed to be the victim, such evidence could not go before the court. That sort of quirky rule has no place in modern system for the fair administration of criminal justice. A defendant is at least well protected when represented by a lawyer at court, as he is when interviewed by the police with or without a lawyer. So you see the importance of what a lawyer, be it at the police station or at court, carries a heavy responsibility which could seriously affect the lay client. As to the admissibility of the evidence, what is on PET form or on the PCMP form, it has also to be remembered that the question of admissibility of evidence as a matter of law and the question whether the evidence should be allowed to be introduced by the prosecution at the trial are not the same. If the circumstances in which an admission was made at a pre-trial hearing were such that there would be any unfairness in admitting at trial, the defendant's position is protected by the court's power to exclude such evidence under Section 78 of the Police and Criminal Evidence Act 1984. What it says is, yes, material that is contained in the PET form and the PTPH form can go in, unless it is unfair and unjust to do so, in which case the defense can invoke Section 78 of PACE. That one would think is fairly a harsh way to look at it. Therefore, let's consider if there is a more liberal way to look at the problem. The cases that comes to my mind are the case of Newell and Villati. Here, defendant was convicted after trial for an allegation of possession with intent to supply. At the PCMH, what we now call the PTPH hearing, the advocate, in completing the form, said in relation to the real issues, no possession. On the day of the trial, again I have the authority here, the defense served the defense case statement and said accept possession but denies intention to supply. On that basis, the prosecution laid a further charge of simple possession and he pleaded guilty to that matter. At trial, the judge allowed the Crown to adduce the PCMH form as an inconsistent statement to show what he has initially said and now is completely wrong. There's an inconsistency. The Court of Appeal, applying the case of Turner, said that it doesn't matter whether the defendant can call evidence to show what was said was not on his instructions. The advocates have ostensible authority to make statements. The advocate at the PCMH should see it as part of their duty to help the court with the case management, setting out the information in the form without the risk of information provided being used as a statement admissible in evidence against the defendant. So this is what I said earlier, that they have that it is a case of assisting the court. Therefore, the position should be provided that the case is conducted with the letter and the spirit of the CPIA rules. The information provided in the PTPH form should not be admitted in evidence as a statement that could be used against the defendant in exercising discretion under Section 78. And in the case of, referring to the case of Firth and Epping magistrates. Then the court went on to say, there might be cases where it was right not to exercise the discretion under Section 78, but those cases would be rare. It is important to note that when one completes these forms, there is the risk of they coming to haunt at a later date. In fact, I should mention, I think it was in the case of Turner where I mentioned Small. That was a case when the series of robberies took place. One of the defendants was initially arrested on his own for a separate matter of possession of a firearm. And he pleaded guilty, not realizing that he will be connected later to other matters. And in that case, when he was arrested and being dealt for the possession of firearm, his counsel made various pieces of mitigation which the prosecution wanted to rely and use in evidence on the series of robberies trial. There, the original trial counsel for possession of the firearms had to give evidence to say that yes, when he made submissions on mitigation, he didn't have authority on certain material. But nonetheless, although it can be done in rebuttal, it doesn't deviate the fact or vitiate the fact that the advocates have the ostensible authority. That is why I said it is important to have written instructions, preferably with an endorsement. In this case of Newell, again the court referred to the case of Turner. This was the one that I was just referring to. And in paragraph 23, the court, no, in fact, I will refer to paragraph 33, which may be more beneficial at this juncture. This is referring to the PCMH form. Given that statutory regime in the Crown Court embedded primarily in the CPIA and criminal procedure rules, and the obligation to put cards on the table, though the attendance of trial counsel at the PCMH, the requirement of PCMH form in the Crown Court should be seen primarily as means for the provision of information to enable a judge actively to manage the case up to and throughout the trial, and the parties to know the issues that they have to be addressed and the witnesses who are to come. The nature of the defense should appear from the defense statement, with the statutory consequences provided for the result, in the result of breach of requirements. The Crown is also generally protected by the principle in JUL justices and penal, if in breach of obligation to identify the issues and ambush is attempted by the defense. This reiterates that the primary purpose is to assist the judge to run the case smoothly. Then, with reference to Magistrates' Court in particular, at paragraph 35, the court made this observation. In Magistrates' Court, where there is no PCMH and no provision equivalent to section 11 of the CPIA, unless defense statement is given voluntarily, the position is little different. The trial preparation form, which has replaced the case progression form, should be completed at the first hearing. It provides for the making of admissions or acknowledgement that matters are not in issue. Where admissions are made in that way, they will be admissible at the trial. Where statements are made on the form which are not made under the section related to admissions, such a statement should be made without the risk that they would be used at trial as statements of the defendant, admissible in evidence against the defendant, provided the advocate follows the letter and the spirit of the criminal procedure rules. So you would note that anything that is written under the paragraph of admissions, formal admissions, that definitely will go in. Where other things are written away from that particular section, might be able to be argued that they should not be. This is why I keep on saying that when one considers the PTPH form or the PET form, they are a lot more involved than what people think. A lot of people think, why do you need to take so much of time to do a simple case? Or write this down. 5 minutes conference with your client. Really? make a decision whether to answer questions or not in an interview. Really? Whereas I would argue against that approach. Spending time with the client, taking a full proof, be it at the police station, in the magistrate's court, or in the Crown Court, then you know what the issues are. Get the client to sign, because otherwise you could be saying things that the client does not necessarily mean because of misunderstanding. If it is written down, if it is crystal clear, then there is no room for argument. Not only that, in my case, I have a rule that I would recommend, that if you are going to complete the PTPH form or the case management form, why not ask the client to consider the little paragraph, what it says, the real issues, or for that matter, even the better case management form. Then there is no misunderstanding. You have written, he has approved it. So, what becomes is his document. The same thing with defense case statements. People are very good at submitting defense statements unsigned with the hope that they will get things correct. I did a trial. My co-defense counsel ran into hot water very quickly because her case didn't run according to what the defense statement was. And the judge was not pleased. And when the defendant came to give evidence, the defendant said, well, I said this to my lawyer. This is not what it is. Rightly or wrongly, my co-defense counsel was put in a very embarrassing situation. And that is because none of us have seen a signed copy of the defense statement. Next question that I'm going to ask, what is meant by a person to whom the defendant refers a person for information? That person is generally called the referee. In other words, you ask the defendant for some information. The defendant doesn't give information, says go and take the information from this person. So that person is, in law, becomes the referee. And in such situations, the defendant is bound by the information given by the referee. There are no authorities on the point of referee concept in criminal law, as at least I know of. But there is an authority which deals with referring a person for information, and that is the case of Malroy, where the case involved of handling stolen goods, and the defendant was questioned as to the value of the property that was in question. He referred the officer to his wife, who prepared a list and gave, which he said he didn't check. The court said, forget it. You referred the person, the police to a person, that person gave the information. So you are bound by that. Therefore, you would notice the importance of use of agents and referees. In conclusion of this part of the program, I cannot overemphasize, and I cannot stop impressing upon you the importance of having a proper dialogue with your client, identifying what the real issues at each stage of the proceedings, and getting things down in writing, preferably covering with an endorsement, because the last thing that any one of us want to do is to be placed in an embarrassing situation of the client saying one thing and we are saying another. Avoid that if at all possible. I hope this part of the program has been useful. I hope you will join me again and that you found this part of the program interesting too. Thank you for your valuable time. God bless.